Hello, my name is Alison Eslick and I'm a Senior Associate in Reed Smith's Dubai office in the United Arab Emirates. In this podcast, I will be giving you a brief overview of the recent amendment to Article 257 of Federal Law No. 3 of 1987, otherwise known as the UAE Penal Code. The amendment came into effect on the 29th of October 2016, and it has proved to be a topic of particular interest and discussion in the local and international arbitration community. In a nutshell, the amendment permits criminal prosecution of arbitrators and experts appointed in arbitration proceedings for failing to act impartially. This was an unexpected amendment that took the arbitration community very much by surprise. For obvious reasons, it has caused serious concern, and arbitrators, experts, and other stakeholders in the arbitration community have a lot of unanswered questions. I'm going to consider 10 of those questions now and provide answers to the extent that we have them. Question 1. Is there an official English translation of Article 257? The answer is no. The official language of the UAE is Arabic, and the UAE Penal Code is published in Arabic. Unofficial English translations of Article 257 have been published online by arbitration commentators and law firms. However, these English translations are not strictly uniform. This may reflect the fact that the translation of Arabic to English is not always straightforward. It really remains to be seen how the UAE courts, if given an opportunity, will interpret the Arabic words of Article 257. Question 2. What does amended Article 257 provide for? Well, Article 257 now permits criminal prosecution of arbitrators and experts appointed in arbitration proceedings for breaching the duty of neutrality and integrity. The penalty for breach is temporary imprisonment of between 3 to 15 years. The critical part of amended Article 257 provides that anyone who issues a decision, expresses an opinion, submits a report, presents a case, or proves an incident in favour of or against a person in contravention of the requirements of the duty of neutrality and integrity while acting in his capacity as an arbitrator, expert, translator, or fact finder appointed by an administrative or judicial authority or selected by the parties shall be punished by temporary imprisonment. Question 3. How is amended Article 257 different to the original Article 257? The original version of Article 257 was aimed at experts and translators appointed by the local UAE courts in civil or criminal court proceedings. However, the amended version significantly broadens the application of Article 257 to now capture the conduct of arbitrators and independent experts, as well as others such as translators, appointed in arbitration proceedings. The previous version of Article 257 was quite different. It provided that the expert who, appointed by the judicial authority in a civil or criminal proceeding, asserts a fact that is contrary to the truth or knowingly gives a false interpretation thereof shall be punishable by confinement for a minimum period of 1 year. The preceding paragraph also applies to translators. Question 4. Does Article 257 create an independent duty of neutrality and integrity? Well, potentially, yes. As mentioned above, Article 257 sanctions breaches of a so-called duty of neutrality and integrity. However, it is not clear whether Article 257 creates a new and separate duty under the UAE Penal Code, or whether the intention is to refer to duties which already exist under the rules of arbitral institutions or the organisations which regulate independent experts. The term duty of neutrality and integrity is not defined by Article 257, and there has been no guidance from the UAE legislature as to what this duty encompasses. This is one of the reasons why arbitrators and experts are so concerned. Question 5. Can unintentional conduct attract criminal liability under Article 257? The answer is potentially yes. The UAE Penal Code provides that an offender shall be answerable for a crime whether he or she has committed it with or without intention, unless the law explicitly provides for intention. Our reading of the translation of the original Article 257 is that it specifically provided for intention as a requirement. This is because it expressly applied where an expert asserted a fact that was contrary to the truth, or where the expert knowingly gave a false interpretation of a fact. However, the word knowingly does not appear in the amended provision, nor does the language regarding asserting facts that are contrary to the truth. This seems to imply that arbitrators and experts can now be held liable under the amended version of Article 257 where they unknowingly act in a manner that is construed as being partial to one party over another. Question 6. Why has the arbitration community raised concerns about Article 257? Well, the amendment to Article 257 appears to have been made with the noble intention of curbing dishonest practices in arbitration proceedings. However, the arbitration community is concerned about the practical impact of this amendment. First, there is no clarity as to what constitutes the duty of neutrality and integrity, or what will suffice as evidence of its contravention. It is simply not clear what acts or omissions will be punishable under Article 257 and what standards arbitrators and experts will be held to by the UAE criminal courts. This has caused understandable alarm. Second, arbitration is often a favourable option in the UAE for dispute resolution because it is a party-driven, autonomous process. However, the amendment increases the possibility of unwarranted judicial interference in arbitration proceedings. The reality is that Article 257 now makes it easier for a disappointed party to disrupt and stall UAE-seated arbitral proceedings by raising claims of bias against arbitrators or experts. Third, the mere initiation of a criminal complaint may lead to serious consequences for an accused arbitrator or expert, including interrogation by the police and confiscation of his or her passport, with obvious reputational and personal consequences for the accused. If criminal charges are laid, the accused will be drawn into the UAE criminal justice system, and it can be very costly and time-consuming to defend against charges. Fourth, it is feared that some of the progress made by the UAE in marketing itself as an arbitration-friendly destination may have been undone with the amendment to Article 257. Will sought-after arbitrators and experts continue to accept appointments in UAE-seated arbitrations? Will parties continue to agree upon UAE-seated arbitrations in their contracts? Only time will tell. Question 7. Article 257 expressly applies to arbitrators and experts appointed in arbitration proceedings. Could it apply further afield? Potentially, yes. The breadth of application of Article 257 is not completely clear. We believe that the intention of this amendment was to capture misconduct by arbitrators and experts in the context of an arbitration proceeding. However, Article 257 applies quite broadly to anyone who issues a decision, expresses an opinion, submits a report, presents a case, or proves an incident in favour of or against a person while acting in his capacity as a fact finder selected by the parties. It is therefore possible that Article 257 could be applied more broadly. For example, it could arguably apply to the engineer appointed under a construction contract to determine parties' disputes on a project, or it could apply to consultants who are appointed by commercial parties to determine and report on the parties' respective obligations in a financial transaction. Question 8. Are there consequences for bringing a false, frivolous or vexatious complaint under Article 257? The answer is yes. The UAE Penal Code permits an innocent person to file a criminal complaint against whoever has submitted a false accusation against him or her. The UAE Criminal Procedure Code also allows a falsely accused person to file a civil suit for damages against the complainant. These are fairly strong deterrents for bringing a spurious criminal complaint of bias under Article 257. Of course, there will always be some people who are determined to bring a complaint. In terms of other safeguards to prevent abuses of Article 257, there has been some talk in the UAE of a specialised screening committee being introduced to assess and filter any complaints against arbitrators and experts under Article 257. The concern is that the UAE police simply do not have the relevant expertise to understand and deal with complaints involving arbitrators and experts. This is certainly outside of their normal daily work. It remains to be seen whether this safeguard will be implemented, and if so, how it would work in practice. Question 9. Is the new law impacting Reed Smith's clients and current cases? Yes, it certainly is. Foreign arbitrators have expressed serious concerns to us about accepting appointments and have asked the parties and arbitral institutions for assurances that they will be immune from criminal complaints. However, as in most jurisdictions, parties cannot contract out of criminal liability in the UAE, and immunity clauses agreed in terms of reference or in the arbitration clause itself will simply not protect an arbitrator or an expert accused of a crime under Article 257. In some of our cases, parties have also mutually agreed to relocate the seat of arbitration outside of the UAE by way of an amendment to their arbitration agreement. This is to avoid arbitrators, experts, and the parties themselves having to travel into the UAE for hearings. Of course, a number of arbitrators and experts are already based in the UAE. Therefore, even if the seat of arbitration is relocated outside of the UAE, there could still be a risk of prosecution for UAE-based experts and arbitrators, particularly if the arbitration has a strong connection to the UAE. For example, if one of the parties is domiciled here, or if the dispute arises from a UAE-based project. Finally, we are also aware that some arbitrators and independent experts are taking a very cautious approach and are no longer accepting appointments in UAE-seated arbitrations. Question 10. Is Reed Smith's construction team optimistic that the UAE will remain an international arbitration hub? The answer is yes. It is only natural that the recent amendment to Article 257 of the UAE Penal Code has caused concern within the UAE's arbitration community. This is a concern that Reed Smith shares. However, Reed Smith's arbitration team has seen the positive growth and improvement of the UAE's arbitration culture over the past decade. We remain confident that the UAE will continue to thrive as an arbitration hub. We understand that the amendment and its impact are being reviewed by the UAE Council of Ministers. We are hopeful that the law will be repealed or amended in the near future. In the meantime, we are confident that the UAE courts will apply this law in a manner that captures the true intent of the legislature, namely to criminalise clear-cut cases of corruption and connivance on the part of arbitrators and experts, rather than entertaining spurious claims. For further information on Reed Smith's Middle East practice areas, including energy and natural resources, corporate and financial law, please visit www.reedsmith.com via the link in the information box below. For information surrounding the content of this podcast or for any UAE litigation queries, please feel free to contact me or any other member of the UAE litigation team on +971 4709 6357 or Eslick@reedsmith.com.